You're Free to Go is sponsored by Milburn Men's Clothing, where top athletes shop for sharp, tailored style. And whether Mark and I are in the studio or the courtroom, Milburn dresses us for success. Mention YFTG and get 10% off at Milburn Men's Clothing, which has been providing the finest in men's clothing and suits since 1946. Call 651 645 2922 or visit www.milburn.com. Welcome back, everybody, to You're Free to Go. Mark and I are here today for our next episode, which we had promised you was going to be about crazy ass cases. But before we get started with that, we want to touch on a couple things regarding crazy jury stories. You know, last episode we talked about crazy jury stories and crazy jurors, and we had such a big response from it. Our producer Ben got calls off the hook about wanting to know more and more about it. So Mark and I are going to start this episode with just a little bit on that topic before we get into a couple crazy ass cases. One topic that seems to be of interest to people is jury pardons, or what we also call jury nullifications. I know Mark has a really great case to share with you about that, but I'm just going to define it for you since you may not understand what that term means, jury pardon or jury nullification. It's basically when a jury hears all the evidence and they believe that the defendant is guilty, but they decide to find them not guilty. Even though maybe the law, under the law and the evidence, applying the evidence to the law, the facts of the law, the defendant is guilty, the jury decides to pardon them or nullify the case and find them not guilty. So it's an interesting phenomenon that sometimes occurs in criminal jury trials. And the good news is jurors cannot be held liable for that. If they decide to vote not guilty, even though the facts are overwhelming that the defendant was guilty, there are no laws that would allow the jurors to be prosecuted. They're very much protected. A jury and a juror is very much protected from being punished for their verdict. And therefore, they do have the ability or the comfort level to maybe find someone not guilty on occasion, even though the evidence really shows otherwise. So, Mark,
And it's a rarity. Let's
very
be
rare.
frank. It's a rare occasion, and obviously judges don't like that. It's disfavored heavily in the law, and lawyers are not allowed to openly ask juries to do that. It's definitely not something you're supposed to do. So you have to kind of be somewhat subtle in your approach.
And you know, Mark,
When
when we talk with potential new clients, what we hear sometimes is, let's say it's a simple case like possession of marijuana. They'll say, how is any jury ever going to find me guilty, even though maybe they live in a state where it's still illegal to have marijuana, when every other state allows it nowadays? No jury is going to find me guilty. So that's where kind of a potential client or a current client thinks, hey, let's roll the dice. I might get a jury pardon or nullification because they just think the law is stupid. Or we also see it with potential victims of crimes where the actual victim, actually, let me talk the Menendez brothers, a perfect example. They allege that they were victims of sexual abuse for many, many years. But when they killed their parents, at that moment in time, their safety wasn't in jeopardy. They weren't in harm's way. Their life wasn't at risk, but they used that as a defense. And they thought maybe a jury might come back and say, well, even though at that moment in time that they killed their parents, they weren't being victimized, but because they'd been victimized over all the years, we're not going to find them guilty of that. So it's when there is a law that applies, but they don't think they should apply that law. So jurors, our clients will ask us that sometimes, hey, why not roll the dice at trial? Maybe we will get that jury pardon.
Well, sometimes you have no choice. Like, for example, I had a case years ago in the Midwest where I represented a fellow, we'll call him Ralph since we're not using real names here.
Right.
And Ralph, I always said Ralph was the nicest, kindest bookie in America. And he was charged with gambling offenses in the state court there. I didn't practice in that state, but somebody had heard that I had some experience with gambling cases, and they contacted me, and I associated with a local lawyer, and the judge allowed me to appear what we call pro hac vice, which was just for that case alone. So I was the main lawyer trying the case, and it was a gambling offense. And Ralph was, according to the DA, the local DA's office, a member of some local crime family. That was never proven. and the judge did not allow them to bring that into evidence or allege that in court. I made some motions and we excluded that, and they really didn't have anything solid on it. But Ralph owned a local little Italian restaurant, and Ralph was operating his bookie operation out of his little office in the kitchen. So, while he was,
With the,
making veal parmesan or
the
whatever, he was
kitchen of
then
the
getting on the
restaurant,
phone.
the whole
He was
restaurant.
get
He's got customers there, and he's running it out of the kitchen of the restaurant.
right,
I
right,
love
right.
it.
He's cooking and he's so, oh, hold on one second. I gotta finish this meal. And he's on the phone taking bets.
Mhm.
And but Ralph was very smart. Smart in the sense that if you owed him money, he didn't really bust your chops. He was a smart bookie in the sense that he never let you get too far behind with him.
Right.
So if you owed him money, he would cut you off, not allow you to make any more bets until, you paid up. And Ralph had another little practice, which was very unique. If you owed Ralph money and you came in and you made some kind of payment, but you couldn't make the full payment, Ralph would sit you down and give you a meal.
No, he's a sympathetic character. I like this
He was
guy.
sympathetic.
Yeah.
He would
Yeah.
give you a meal. He didn't chase after you. So the fact is, we had no defense. They had clear evidence. They had wiretaps. They had some people, who had bet with him, testify against him reluctantly. You could see these people really like Ralph, and in fact, in cross-examination of them, I was able to bring out what a great guy he was and how he fed the meals, and we talked about the meals, and the jury was really fascinated by it.
After the
But
trial,
the
I bet
crazy,
his restaurant became very popular.
very popular, and it was a tiny restaurant. I think there were 10 tables. I
Nice.
mean, I ate there once, and I have to admit the food was good. Oh, he wasn't there at the time. Um, so they didn't offer, that is, the DA's office didn't offer us any kind of deal in this case. And it seemed like such a stupid prosecution. And this is an example of what you were saying earlier about, being charged with marijuana in a state that hadn't legalized it yet, where everywhere else had been legalized. I mean, betting was so common. There was sports betting in Vegas. And the crazy part about this case was I had no defense. They offered us no kind of deal. Ralph didn't want to plead guilty and have all sorts of consequences as a result. So he went to trial without any real defense. And I decided the only defense I could lay out was to put, on trial, not Ralph, but the prosecution for prosecuting this stupid case.
Sure. Which
And
I think
it was
jurors are receptive to that. They don't like
right.
wasting tax dollars, wasting their own time having to show up in court every day. Right. So I think
Right.
it's great.
So it was a classic jury nullification, but I couldn't ask the jury to disregard the law openly. And in fact, as you know, judges tell the juries that they must follow the law. At the end of a trial, jury is given instructions on the law, and the judge hammer into them the fact that they must follow the law. And you can't argue to them openly that they can't follow the law or that they have the right not to follow the law. But the truth is, they make the final decision. And at the time, there was a movie that came out maybe about a year ago called The Verdict. You remember that
I
with
did.
Paul Newman?
Yes. Excellent. Yep.
Fabulous movie. My one of my favorite legal movies, and phenomenal acting by Paul Newman, who I thought should have won the Academy Award that year. Um, and in that movie, if you remember, it was a malpractice case against doctors at a hospital. And in that particular movie, in the case in court, what happened is there was a witness who testified clearly about some malpractice, but for some legal technicalities, the wily attorney on the defense side got it all excluded after the jury had already heard it. And the judge very sternly looked at the jury and said, "You must disregard what you just heard. You can't consider it in your decision. You must forget that you heard it at all." Of course, is a little absurd
Right.
because they already heard it.
Yes.
And at the end, Paul Newman gets up to make a summation, the closing argument at the end of a trial when lawyers get to sum up what happened and to try to appeal to the jury their particular case and why they should vote in favor of their side. And Paul Newman had nothing to say directly about the case. And he went into this long speech. And at the time, I thought, boy, this is a little kind of weird. Um, but it was very effective. And he basically said, you are the law today, not the judge, not the court. You are the law. And, you need to seek justice. I know justice is in your heart, blah, blah, blah. It was much more eloquently done.
Mhm.
And I decided to do something like that at the end of the case. And one of the great things I had working for me was when they put the case agent on the stand, the local cop from the vice squad, and he started testifying. I took out the local newspaper from the day before, and I showed it to him. I said, "Do you recognize this?" The prosecutor objected because we hadn't shown him the exhibit before under the rules of evidence. And I said, "Judge, this is for impeachment." And the judge allowed me to do it. And said, "What is this?" He said, "Well, it's the local news, whatever the name of the newspaper was, for yesterday." I said, "Yeah, let's open to the sports section." And I introduced the paper into evidence. Everybody's looking at me like, What am I doing? What kind of idiot am I?"
Uh-huh.
And I said, take a look at that page in the front page of the sports section. What's that on the top line there?" And he's looking at it, and I can see he knows exactly where I'm going at the time. And I said, "Come on, you can tell us. What is that?" And he still hesitated. I said, "Well, aren't those the betting odds for those particular sports events?"
Mhm.
And he goes, "Yeah, those are the odds." I said, "Well, why are they in the newspaper? What's the point of posting the odds if nobody's gambling?
Right. That's good.
In the
Yeah.
local newspaper, they're putting the odds. Well, what are these people in the middle of this Midwest town going to go all of a sudden and walk over to Vegas
Right.
a
Right.
1,000 miles away?
No, they need a bookie.
They
Right.
need a bookie."
Yeah. Uh-huh.
And we
Yeah.
did things like that throughout the case. And ultimately, I made this speech to the jury at the end about, that they are the law, that they're the ones to make, do justice in this case. And they have to find it within themselves as what is just. And lo and behold, they found my client not guilty.
Wow. Wow.
The judge was amused by the case. And I think he kind of recognized that this was a stupid case to occupy his courtroom to begin with. Prosecutors were a little pissed, but that's the way it goes. And my client was very happy. I said, "But listen, I think at this point you'd be safe just to continue cooking
Right.
and not
Yeah.
not booking,
Okay.
just cooking,
Yeah.
not booking."
Yeah.
So
Two thoughts come to my mind. One is I want you to address whether how long a jury verdict like that took, and number two, sometimes at the end of a trial, a judge will admonish the prosecutor, the state, when they bring, a case that they think was frivolous and shouldn't have been brought before and tied up everyone's resources and time and so forth. So I'm just wondering, because clearly this judge, I think, picked up on that. Did they say anything to the state and say, "Hey, you guys should think a little more before," even though it's not their role, there's separation of powers and so forth. But I have had judges say that to the state, like, why'd you tie up 3 days of court or 6 days of court or 2 weeks of court on a case like this when your evidence was so weak? So,
actually, no. And the strange part, the funny part about this was, the judge said after the verdict was announced, words to the effect, "You're free to go,"
yeah,
to my
there,
client,
uh-huh,
um, which was, music to our ears.
yeah,
And then the judge started to get off the bench, I remember. And I turned to look at the prosecutor and the case agents. They were already halfway out the courtroom.
wow,
They were running out of there.
yeah,
Meanwhile, the jury was a couple of the jurors were still in the jury box. And, my client was looking at them and saying, mouthing thank you. And he started to get up. And one of the jurors I still remember this today, came out of the jury box, like walking towards my client. And I'm thinking to myself, what is this guy looking to make a bet?
Right.
What's going on
He's
here?
looking for the
And then
odds.
I grabbed my client's arm because I didn't really feel it was appropriate for him to have contact. And he just waved at the jury and we walked out. And it was sort of like my cousin Vinny. I said, let's get the heck out of
You're
here
right.
quick
Yeah. Before the judge
before they
finds
change
out.
their mind.
Right. Yeah.
Right.
And
But
that,
it
mhm.
was really funny. You know, it's interesting. Juries do have a lot of power. And curiously, in I think 5 or 6 states still, juries actually are allowed to pronounce the sentence.
Right.
I think Kentucky, Arkansas, Missouri, I'm not sure Texas or Virginia. Uh, and
Yeah.
it's kind of interesting because, you know, not only do they get to make a decision on guilt or innocence, but they get to weigh how important it is for them to sentence seriously or with mercy. I had a case many years ago in federal court where I had a client who committed this elaborate scheme, um, but we had an insanity defense, and this was an insanity defense before what we call the Hinckley Amendment.
Right.
If you remember, John Hinckley shot President Reagan.
Sure.
He went to court and he was tried and he raised the defense of insanity. And at the time, the burden of proof was on the prosecution
Right.
to prove beyond a reasonable doubt that the defendant was able to distinguish, you know, right from wrong, whatever the standards were for insanity. So the burden of proof was on the prosecution. Hinckley claimed he was a schizophrenic, produced evidence of it. The jury rendered a verdict of not guilty by reason of insanity. Everybody went nuts. Ultimately, what happened is Congress enacted the Insanity Defense Reform Act of 1984. And what happened is now the burden of proof was on the defendant to prove by clear and convincing evidence that they were met the test of insanity. So, but anyway, I had this case before the Hinckley Amendment. My client, we claimed, was insane by reason of a compulsive gambling and being an alcoholic.
Wait, this is a different case also involving gambling.
Yes.
Okay. Okay.
And the bottom line is that I remember the day, one of the days in the trial, you couldn't get a drink in the local town because I had every bartender as a witness coming on the stand. My guy would drink a fifth of scotch before noon
Oh boy.
every day. He owed
So
Vegas hundreds of thousands of dollars. Um,
every,
anyway,
every,
he was found guilty,
mm,
but the jury, when they pronounced the verdict, and the judge read the verdict to my client, the jury foreman stood up and he said, "I remember this very plainly." He said, "Judge, we want to make a recommendation for sentencing." Of course, they weren't allowed in
not in
federal
that
court.
state. Yeah.
But the recommendation, he said, the jury all unanimously voted that they wanted my client not to go to jail, but to get treatment. So it was sort
Hmm.
of a mild form of jury nullification.
Yes, I would
Uh,
agree.
so
Yeah.
it's crazy, you know,
Yeah.
juries do have enormous power and you need to appeal to it. And I
It
think
is.
that's the beauty of our system is it's not left to one person, to a judge. It's left to six in state court, some state courts, 12 in federal court, people, allegedly your peers. And that's the beauty of our system here. And
And
God forbid we should ever change that.
agree, agree. And you mentioned, and I'm not sure how many viewers realize this, but the jury decides in almost every state except 5 or 6 only the issue of being guilty or not guilty. And by the way, not guilty doesn't mean innocent. It just means the government didn't prove the case beyond a reasonable doubt. So jury comes
Right.
back guilty or not guilty. And then the judge is the one, the jury's excused, by the way. They leave the courtroom, they get a pretty certificate thanking them for their service. And then the judge that day or weeks later pronounces a sentence. In those few states that we mentioned, the jury may also pronounce sentence. What's interesting to me always is you're never allowed as a lawyer to explain to the jury that if you find my client guilty, he's going to be sentenced to 30 years, 15 years, whatever the draconian sentence might be. But if they did know that, I think we'd see a lot more jury nullifications or jury pardons, because they'd realize, well, this crime is a crime, but we know if we find him guilty, he's going to be launched with a sentence and with the rest of his life sit in jail, and that doesn't seem just or fair. So we probably could see some more not guilty verdicts. So I wonder if in those 5 to 6 states.
That's interesting you
Yeah.
bring that up, because when you think about it, the one exception to that is in murder cases,
True.
because juries know, especially if it's a case, an egregious case in a state where there's a death penalty, and they'll be told, they'll be what they call death penalty qualified during jury selection. Um, they'll be asked questions about by both sides how they feel about the death penalty, because obviously people who would have religious or other moral prohibitions against imposing the death penalty are going to be excused from the jury. They won't be allowed to sit. So in those cases, juries know either it's going to be a death penalty case or a life in prison case. So they know right away how serious it is, and they know the stakes are very high, which is, I believe, part of the reason that if you look at a lot of these high profile murder cases, you see a lot more acquittals than in normal cases. Certainly, in typical, like we said, federal cases, criminal cases, which don't really involve murder cases per se, you're talking about 90 something percent conviction rate during trials. So you see a lot of
Yeah.
acquittals in murder cases. The other thing that happens is when you have a co-defendant who's testifying against your client and they've been charged with the same thing, you're allowed to ask them what they were facing and what they expect to get as a result of their testimony. So that's sort of a backdoor way
Hmm.
of having the juries understand what your client's facing.
Right. And from the
But
defense perspective, I think it's super powerful and important.
yeah,
Um, Sometimes we'll see, if you've never been on a jury, you may not realize you can actually ask questions during the jury deliberations. You can send a note to the bailiff who brings it to the judge, who then discusses it with the attorneys, and it'll say, hey, the jury has this question. And then we decide how to handle it, bring the jury back in, answer the question, tell them we can't answer it. But I've seen many times in my 150 plus trials where the question says, Judge, if we find them guilty, what's he facing? And it shows that that is on the juror's mind. It's
yeah, that, by the way, that's very interesting you mentioned that, because that's one of the most agonizing times for a defense attorney while you're waiting for a verdict. And you don't know what the jury's thinking until they come out with a question, and you are apt to misconstrue the question. You sit there and you talk amongst your co-counsel. Oh well, what does this really mean? And
oh,
you agonize over it, and you torture yourself. Well,
mm,
does this give you an idea that they're thinking not guilty, or does
mm,
this look like they're
mm,
already made a decision on the first
right,
count and now they're on the second count?
yeah,
You can go crazy over that, which is
mm,
why when I hear that you got to come back into the courtroom, the jury has a question, I have a lump in my stomach
that's right.
because I
Mm,
don't want to
right.
know.
And the worst thing you can do is turn to your client and say, based on this question, this is good news. This is good news for us. 'Cause then for sure it's going to go against you.
Yeah, and then the
Yeah,
client. Oh, the other thing
yeah,
that's very interesting is when the jury finally comes out to announce the verdict, and a lot of times, they don't look at you, and your first reaction is, "Uh oh, it's going to be a guilty verdict." Um, But more often than not, it's just they don't want to look at anybody.
right.
Sometimes they don't look at you, they don't look at the prosecution. Now, if they come out and they're smiling at you and they're smiling at your client and they're not smiling at the prosecution, that's a good sign. Sometimes they come out and if they're smiling at the prosecution and they don't even look at you, that's a bad sign. But more often than not, you can misread it. So a lot of times when they come out, I look in a different direction. I
Right.
don't want to see what they're looking
No.
where they're looking or what they're saying.
It is a it is
in their
it's a
minds.
well, just think, we know no matter what, we're going home at night, so it's that stressful for us. I can, I try to put myself in our clients' shoes and think about it. It's a million times more stressful for them, that moment between the end of closing arguments and that verdict. It's a
Oh
really,
yeah,
really
and waiting, you can wait around. I remember in the Miami River Cops trial, we waited like 12 or 13 days for a verdict. It was
yeah.
absolutely insane.
And
And
there's also predictions on that. The short verdict is a guilty verdict. The long guilty is a not. The deliberation is a not guilty verdict. Sometimes it's true, sometimes it's not. There's no perfect
no, yeah,
science to it.
absolutely.
You
Yeah,
know,
absolutely. So,
I
but
have
it's crazy stuff with juries, isn't it?
yeah. This is a side story. It's a difficult one. I was waiting for a jury. I was out in the hallway looking out a beautiful window, talking to one of the bailiffs from the courtroom, and we're looking at downtown Miami, and there's a high-rise building, kind of about 2 blocks away, but we had a perfect view of it. And the bailiff and I are just talking. We're kind of chatting about life and waiting for when the verdict will come and so forth. And we see like I don't know, look like a bag of sod or some big bag fall off of the ceiling of one of the skyscraper, a couple blocks away while we're sitting there talking. And all of a sudden we're like on the 15th floor. So we're kind of looking down, see all the city streets of Miami. All of a sudden we see all these emergency vehicles going toward that location. It turns out that we were witnesses to someone jumping off of the roof of the building. So
Oh my God.
while we're waiting for this verdict, so we saw someone jump. We didn't realize what it was until obviously we saw the ambulances and started hearing the news over the radios and so forth. But it was a tough case. It was a situation where it ties into criminal law. This gentleman was working at downtown Miami. Police came to his place of work and said, "We are investigating you for possession of child pornography. Would you like to talk with us?" They said, "No, I'm not talking with you." They said, "All right, well, we have a search warrant for your house. We're going to head to your house right now and search your home pursuant to this legal search warrant. Do you want to come and witness the search?" He said, "No, I don't want to do that." Instead, the cops went forward with their search of the home, and he went to a lawyer's office in that skyscraper. That lawyer is still devastated by what happened. He spoke with the gentleman. He said, "These are really, really tough cases. I hate to tell you, but you're in for the fight of your life. And I can represent you. I've handled these cases and so forth." But I don't think he gave the individual much hope. And at the end of the meeting, instead of going down the elevator to his car and leaving, he went up the elevator to the roof of the building and jumped.
Oh
And
wow.
yeah, we were
That's
just
that's
happened to
that's
see it. It was
that's
really,
sad.
really, really sad situation. So that lawyer's never been the same. He feels, somewhat responsible and so forth. It was, but I'll never forget that with this nice bailiff and I just watching, and we saw this whole thing. You're Free to Go is sponsored by Lang Realty, South Florida's premier residential real estate broker. Whether you're buying, selling, or renting a home or condo, Lang's experienced realtors are standing by ready to help you. Contact one of Lang's top realtors today at 561 703 2427. What a heavy.
I have one more jury story to tell
Okay.
you very quickly because it just reminded me. When I was a prosecutor, I don't even remember the details of the case. It was so long ago. But when the jury verdict was out and the defendant was on bail, um, obviously he was wherever near the courthouse. The judge had instructed us all to be close by in case there was a question. We had to get back and discuss it. And then when there was a question, we all came back and the defense attorney was there, but the defendant wasn't there. And the judge asked the defense attorney, "Where's your client?" He said, "I don't know, Judge." Well, the judge says, "Well, you better make sure he gets here." And somehow they allowed the decision to be made on the question without the defendant there, which I don't even know if that was a good idea. But in any event, then there was another question, and the defendant wasn't there. Now it was pretty obvious that he was, you know, decided to
Yeah, flee.
to flee.
he thought
And
he thought someone said you're free to go.
right, right, a little
Yeah,
early.
yeah, a little.
So what happened is now we know we've got a jumper on us, not a jumper like your guy,
Right.
uh, but and then the verdict came down, and everybody's wondering where this guy is. And I remember one of the cops working on the case knew that the defendant had a girlfriend in another city. So what happened is we put LaGuardia Airport and Kennedy Airport on alert. I don't even know if we did Newark, but we did the two main New York airports. And sure enough, he was found there waiting by a phone. What happened, we ultimately learned,
Yeah.
he was waiting for someone in the courtroom to listen to the verdict
Verdict.
and call him. And if it was guilty, he was going to fly out. He had a ticket.
Of course.
And if it was not guilty, he would come back and make up some malarkey story about where he was. If he got held in contempt, how much time could he do? But the bottom line is that he would have walked out free ultimately. Um, but the judge was very smart. And judges do this. The judge held the verdict in abeyance. He didn't read it openly in the courtroom. So the defendant never got the call. He was waiting by a bank of payphones back in those days. You
Oh,
know, payphones was
right.
before cell phones.
Yeah.
And they found him.
Wow.
So
What
he tried to trick the system, but it didn't work.
did the judge hold him in contempt or do anything or just bring him to the court? What did they
I
do?
remember, well, ultimately the verdict was announced. It was guilty.
Okay.
And I remember that the judge, there were further proceedings to be held on that case, but they were postponed another month. Meanwhile, I had left the office because as I told you, I worked for a year producing off-Broadway plays
That's
before
right.
going back to the practice of law.
Yeah.
Um,
Yeah. That and
anyway,
you used some
so
of that
interesting
background in
story.
that gambling case when you pulled out the newspaper very dramatically
Yeah.
and showed them the top line. Read, it's okay, you can read it. I think
Right.
you're going to be up for your own Oscar or Emmy, whatever.
Yeah, well, I don't know about that,
Well,
but
they
in
do.
any
A
event,
lot of us trial
great
lawyers do
story.
take acting classes because when we're in front of a jury, there is a component of it that obviously we're not acting in the sense that we're reading fake lines that someone wrote, but we do. There is drama to it.
Oh yeah,
Yeah,
there's a lot of drama to it. Sometimes if you overdo it, you have to know the audience. And
yeah,
some judges are very strict about that. I mean, for example, where you stand in the courtroom when you're addressing the jury. You see in a lot of movies and TV shows depicting courtroom scenes where lawyers are right up against the jury. They're literally leaning on the
right,
on the rail there, the jury rail. You're not allowed to do that. And
right.
certainly in federal court, you're not allowed to do that. A lot of times they try to stick you behind a podium. And I've had judges that don't even allow you to move from the podium, which is very, disturbing because in order to really make an effective argument to a group of people, you need to be able to emote. You need to be able to express yourself. And sometimes you need to even pace around.
Mm,
Um, so it depends on the case, depends on the courtroom, and also depends on the locale and the jury. If you're like I remember in one of the Gotti trials, Bruce Cutler, who was one of Gotti's first lawyer, very effective courtroom lawyer. In fact, he and I worked together in the DA's office at the same time. Bruce took the indictment and ripped it up and I heard and threw it in the garbage
right.
and said that's what it's worth. Well, apparently he got away with it there in New York. You try to put that in some places, more conservative places around the country. Um, not only is the indictment going to be in the can, you're going to be in
He's
the
going to be
can.
in the can too. Yeah.
Right. So
You
anyway,
talk about the position of it's always to me I feel it's unfair. I understand the reason behind it, but the prosecution, the federal agent, the government, the state attorney, whoever is prosecuting the case, they're always closest to the jury, and the defense is always farthest. I get it. They don't want the feeling that is, hey, we don't want the jury too close to a defendant. But at the same time, getting back to what you just said about, emoting is a very important part of our job, and connecting on an emotional level and conveying really our feeling, our passion about something. It's harder to do if we're 20 feet away, and it's easier for the prosecutor who's literally, 3, 4, 5 feet away from a jury, and they can really have better eye contact. And so sometimes a good prosecutor will use that to their advantage, I think.
You're right.
Yeah.
And it's interesting because the first time I went into federal court in Boston, and I've been practicing in Florida where the tables were the way you're talking about, I noticed that instead of the tables being side by side or even perpendicular, they were right behind each other. There was a table
Yeah.
closest to the bench, the judge's bench, and then a table behind it. And I'm thinking to myself, where do I sit? I don't even know. And obviously, the prosecution was in the table ahead of us, and we were behind on the defense side. So it can be
Yeah.
confusing sometimes. You go into a courtroom for the first time, you don't know. And that's always been a habit of mine of throughout the United States, having tried cases in, my God, over 30 states, 30 jurisdictions. Um, I always try to go to the courtroom first before the trial, a couple of days before, the day before, the morning before, and kind of like sit there alone in the courtroom and get a sense of, I'm not going to say the vibrations, but
Right.
something about it. I wanted to feel comfortable in that environment. And I wanted to know where I could look, where I could walk, what the lines of sight were.
Right.
Um, it just
Yeah.
gave me a feeling about the
Yeah.
courtroom so that when the trial started, I felt a little more comfortable operating in there.
Right. Observing the judge and their style. I've
Right.
observing the other local lawyers, how they're handling their caseload and so forth. Yeah. It's
Sure.
good.
Seeing a judge, for example, in other
Yeah.
cases,
Right.
sometimes you sit and you watch the judge sentence people or handle cases before you get a sense of the judge, especially if it's a judge you do not know.
Right.
So,
Yeah. I
so
think.
we had promised
Yeah.
some crazy ass stories.
Well,
Uh,
I hear it, and I think Ben might have had a question to our engineer. So let's do that, and then we'll get back to it.
So I just actually more so a statement. I just wanted to let you guys know that what you're doing is amazing. I didn't really understand what a jury was. I didn't really understand the role and how much almost it is an honor. So it's really cool that you guys have kind of broken some things down. And just from an outsider, it sounds way less scary. To be a part of a jury. A lot of the times people are like, oh, you got jury duty. And, you said it earlier, but I just think it was really admirable how you guys kind of broke down and explained it.
Oh,
So
good. Thank
yeah.
you. Thank you.
well, thank
Yeah.
you. But look, it's clearly an imposition on people's lives. But when you think about it, it's such an important thing for everybody to do. I know judges, I've heard judges give speeches that jury service is just as important as serving in the armed forces in protecting the freedoms of this country. And I think to some degree that's true. Um, I wish, Guy, I don't know, Guy, I don't think you've ever sat on a jury, have you?
I've tried, but I never get picked. I get
Me neither.
I get subpoenaed. Yeah.
No one's going to pick me,
No.
especially given the fact that,
Yeah.
I taught trial lawyering for over 20 years in law school. I mean,
Yeah.
I'm the last person they're going to pick. I'm hoping someday when I retire, maybe I'll be picked, but by then
Right.
probably won't see. So
Yeah. But I think Ben's question or his point is really well taken. Your jurors are taken care of nicely in the system because it is such an inconvenience, but it is such an honor, and it's so appreciative of the staff, whether it's the prosecutor, the defense attorney, the judge, the clerks. Everyone appreciates people who show up to fulfill their jury obligation, because but for them the system would come to a halt. We have to have our jurors showing up and doing this job. It's so important. And I mean, judges will even buy them lunch. They'll bring them gifts. I remember I had a Valentine's a trial in the middle of Valentine's Day. The judge brought them all Valentine's candies. And occasionally the judge will even turn to the jury and say, hey, do you guys have any questions for the witnesses? Doesn't happen often, but occasionally they might. So I think it's important for a juror to know, since Ben points out, maybe there's some intimidation or fear or anxiety about, hey, being subpoenaed for jury duty. Other than a lot of waiting around and maybe being bored and maybe being shuffled around from the jury assembly room to the courtroom, back to jury assembly, into the jury deliberation room, back and forth, which is annoying and inconvenient. You really are, treated well, and there's no pressure, and it's typically a good experience. When I mentioned in our last episode how much I enjoy talking to jurors after a trial, and they typically are really, really happy. They write letters to the judges thanking them for the opportunity. So in general, it's a positive experience. Getting to our next topic, we clearly, I know for sure the case I want to talk about is going to take a lot of time, and I don't think we have that time today. I'll just say two things about it, though, because they tie into the topic we've had for the last 40 minutes, which is the jury selection. I'm going to talk about, it'll be next episode, though, about the John Goodman case. And I'm not talking about the actor John Goodman. I'm talking about the billionaire polo mogul John Goodman, and I'll get into his background a lot more next time. But the connection to the jury is that there was a change of venue that occurred in that case. So there's two situations that sometimes occur with jurors, what's called being sequestered or a change of venue. That typically happens in really high-profile cases where the judge or the attorneys, judge and attorneys are concerned that the jurors are going to be influenced by the media that is just overwhelming on a particular case, or just simply being a family dinner or at a restaurant and hearing people talking about the case because it's so high profile that it's in the news and the scuttlebutt is out there, everyone's talking and pontificating on, who did what, who's guilty, is he not guilty, and so forth. So there's two mechanisms that the judge can impose to protect from a jury being prejudiced by all that chatter. One is sequestering them, where you may know from movies, you actually get put in a hotel, and your devices are taken from you, so you can't go online, and you're not supposed to watch the news because it'll be reported on the news. But there's another one, which I did in the John Goodman case, which was a change of venue. It was an international covered story in international news, but it was extremely covered, intensely covered in Florida, so we're on the East Coast and the south portion of Florida for sure. And it was going to be impossible to get a jury that didn't know about this case. It hadn't already prejudged the case. So on the defense side, we asked for a change of venue, meaning put this case in Atlanta, put this case somewhere else where we can get a jury that maybe hasn't seen the news, even though it was also international. The judge in that case decided, we're going to pick a jury in Tampa. It was far enough away that maybe they hadn't heard that much or followed the news that much.
The following presented in
But
first person
what was
occurred
so,
with different
talk about
counsel.
inconvenience to jury. It's fine. The lawyers, we got up, we packed our suitcases, we went to Tampa for a week, and we picked a jury. But that jury then had to come to Palm Beach County, Florida, and live out of a hotel away from their family for the entire trial. So that was an example where judges got creative and said, all right, we're going to pick a jury from a different jurisdiction in a different
But
media
bring them there?
and bring them back to Palm Beach County for the actual
Wow.
trial, because there were hundreds of people in Palm Beach County that needed to testify. And it was easier to bring, 20 people over from Tampa to Palm Beach than bring, 150 witnesses and so forth to Tampa. So that's how that judge handled it. So I don't know if a story comes to mind for you, Mark, on change of venue or sequestering. And then the other connection to John Goodman I want to talk about is a jury consultant, which was very significant in our John Goodman trial. But do you have a story that comes to mind on a?
Well, interestingly, in all of the cases that I've had, and I estimated somewhere between 275, 300 jury trials, um, I don't think I've ever had a jury sequestered. I've had juries admonished about, watching the news, which of course is somewhat absurd because, the judge can tell them that, but nobody's going to monitor it. And some people probably would abide by that and some don't. So I haven't had that experience, surprisingly. But I have had cases where jurors have gone off the rails, so to speak, during the course of a trial and doing stupid things like going to the scene of a crime
Right.
when they're not supposed
Right.
to, or actually doing their own investigation. And now, with the advent of social media, and of course with the availability of everybody on the internet, it's kind of funny. I have a 10 and a half-year-old granddaughter, and frankly, she could go on the internet and probably be as effective as one of my investigators back in the 70s or 80s, because everything is right there at your disposal. And I had one case in which one of the jurors went and did this whole investigation on the internet. And I think the jurors, I mean, that was improper to begin with. But on top of it, what compounded it was the juror went ahead and told some of the other jurors about what they did. And one of the other jurors, recognizing that it was improper, reported it to the court. And then we brought the juror into the courtroom and questioned her. And I remember her response was, "Well, I didn't know I wasn't allowed to do that." And, the
Right.
judge, dismissed her from the jury. And that's, by the way, why we have alternates. And we never even talked about the idea of an alternates, because I don't know how many people out there really understand that when you pick a jury, especially in a case that's going to be lengthy, you have to pick alternates. And the reason you have to pick alternates is in the event that, jurors get sick, or for some other reason they're unable to continue to serve, you got to replace them with the alternates. So the alternates sit there during the entire trial, just like all the other members of the jury, listening to all the evidence as though they're going to vote. And then at the end of the case, if they're not called upon to replace somebody, they're dismissed. They're not there for jury deliberation.
Yeah, that's
So during the entire time,
mhm.
you're doing all the work listening, and then you don't get a chance to vote. But sometimes they're told to stay, around. Don't go anywhere, because if we lose a juror during lengthy
Right.
deliberations, you may have
You're
to come
jumping
back.
in.
And if you come back to be replacing one of the jurors, the deliberations have to start all over again from
Right.
scratch.
That's right. And
So it's crazy.
when I talk to those alternates, like you said, at the very end, all the closing arguments are over. The judges give the instruction, say, "Okay, go back to the jury deliberation room and begin your deliberations." They say, "Except juror number 10 and 11, unfortunately, you're not on the jury." I would say when I talk to them all the time, 50% of those released, juror alternates say, "Damn, I really wanted to be on the jury." And 50% of them say, "I am so glad. I never would have wanted to have to rule on this case. Too difficult, too stressful. I'm really happy not to be on it." In my last trial, by the way, I had used an alternate because the juror showed up drunk as a skunk on day two of trial. Couldn't slurring speech, couldn't stand up, dropped their pocketbook was a mess. So we discussed it with the judge, decided to excuse that juror, and the first alternate took their seat. So we do see that a lot.
Yeah,
Uh,
and I had a
yeah.
case in which we lost a juror. We only had one alternate left. We had picked two alternates, but the other alternate became ill during the time of deliberations. So we only had one other alternate. And it turns out when the judge kept calling for the alternate, the courtroom deputy found out the alternate had gone to American Samoa,
Oh.
which is like halfway around the world. and and luckily, that alternate was coming back 3 days later
Mhm.
or 4 days later. Wasn't that
Oh.
long. And because the deliberations had gone on for 2 or 3 days already, and they were going for about a week. So we actually had to stop deliberations, wait for the alternate to get back from American Samoa.
Mhm.
The
Yeah.
judge was very, very angry,
Sure.
and the judge wanted to take it out on this particular alternate. Well, we convinced the judge, both the prosecutor and I, "Judge, if you're going to do that after the deliberations.
Of
You
course.
do that now, you're prejudicing that juror." It's not a
Right.
good idea. And the judge wisely
No.
decided, all right, I'll hold off.
But they're so cognizant, judges, of the inconvenience to jurors, and that's the perfect example we were just talking about, how it drags out that experience for jurors, with pulling them out of their life, their jobs. It's very frustrating. And by the way, we didn't even mention, if you get called to federal grand jury duty, that's often like a 6-month jury subpoena where you maybe meet twice a week for 4 hours each time. It goes on for months and months and months. But that's pre-indictment. That's not in front of a trial.
Do we have any
Yeah.
time left to tell one
Yes,
story about? Do we have any time
yeah,
left?
we think we do. Yeah, go ahead.
Okay, because you were just mentioning something that's very important that is absolutely a truism. Judges are very protective of the jury's time, recognizing how important it is to have jurors deliberate properly, to attend and listen to the trial attentively. Judges are always very deferential to juries, and they do not like it when you keep a jury waiting. So I have this one story, and it's about Key West. Key West is the most laid back place in America, probably. And I think I may have mentioned earlier, in Key West, formal wear is clean shorts and a clean T-shirt.
Right.
Well, we had a case in which we went out, drinking with the judge that night. And did I tell this story already? I don't think I did.
I don't know. I don't
But
think so.
I may have mentioned that we did that from time to time. And we had a judge whose only rule was we can't discuss the case. So prosecutors, defense attorneys would be there. We'd be over at Sloppy Joe's drinking late at night with the judge. Judge was great, off the bench. On the bench, she was tough.
You're like,
Some say a tyrant.
this is the
Yeah.
judge I was having a great time drinking with, laughing last night, and now
Yeah.
they're ruling
Oh my
against me.
God! Then they'll rip you apart in the
Right.
courtroom.
Yeah,
So, well, wait a second. That's the same guy.
yeah.
But it was great. I mean, it was a very convenient thing, and it was a very good atmosphere. I mean, we didn't discuss the case. We just talked about life. We talked about crazy things. And I remember one night, one by one, we're all kind of leaving, and by the time I left with the main prosecutor, there was only one attorney left. We'll call him Mr. Mulligan, for
Okay.
lack of a better word. I don't want to identify this lawyer by name. And Mr. Mulligan, John Mulligan, was left with the judge, and they continued drinking. And the next morning, we all get to court, and everybody's there, and we're waiting for the judge to take the bench. I think we had to get there by 9 o'clock. It's now about 9. The judge takes the bench, and everyone's there except John Mulligan. And the judge asks us to announce our appearances. And then the judge, noticing that Mulligan's not there, says, well, where is Mr. Mulligan? We go, we don't know, Judge. Judge says, well, where is he staying? We're keeping the jury waiting. He didn't want to do that. So where is he staying? We said the Pier House. The judge picks up the phone that's on the bench that you can hear through the PA system in the courtroom, and dials the Pier House and says, John Mulligan's room, please. And all of a sudden it rings 3 or 4 times, and then you hear, hello.
Oh.
And the judge goes, Mr. Mulligan? Yes. This is Judge, whatever the judge's name was. Where are you? Judge. I'm sorry. I'll be right there. And hangs up. And now we're waiting.
Oh,
10
boy.
minutes goes by. 20 minutes goes by.
It had to be 100 feet away. Everything's so close down
30
there.
minutes go by. Steam is coming out of the judge's
Oh my
ears.
God.
You can see how angry, because we're keeping the jury waiting,
Right.
which is the cardinal
Yeah.
sin in a courtroom.
Yes. Yep.
Finally, and we're all taking bets amongst the other defense attorneys. What's going to happen to John? Is he going to go to jail? Is he going to be fined? How much is the fine going to be? Whatever. It's like I said, off the bench, great guy on the bench. You don't want to
Right.
mess with this judge.
Oh boy.
Finally, the back door is open to the courtroom, and in walks John, sweating profusely, his tie askew like this. He's got pieces of tissue paper on his face where he cut himself shaving hastily. And he walks up, and the judge says, "Mr. Mulligan, what's your excuse? You're keeping the jury waiting. It's 45 minutes that we've waited for you. You need to justify why you're so late." And it's just John's way. And this guy was a great guy, this lawyer. He says, "Well, Judge, if you hadn't gotten me so shit-faced drunk the night before, I would have been here on time."
So he probably got credit for being honest.
Right. And the judge had nothing to say.
Yeah.
He said, "All right, let's call in the jury."
I love wrapping it up on that story. It's funny, even though the topic was juries and jurors, we just intertwine all these great, cases and crazy ass cases like that one. And we'll continue. We had teed up 2 really great cases for this episode. We're going to push them off to next week. The one that I'm talking about, John Goodman, there was a jury consultant who said, let's pick a wild card for this jury, which is a strategy jury consultants often use. And you'll find out next week when I talk about John Goodman, how that strategy paid off in winning a new trial by having a wild card juror on the case. So we'll get into that. That was all the result of a jury consultant's advice. But I think we'll wrap it here for today. Mark, was a long episode. I enjoyed it as always, going back and forth with you. The banter is awesome.
I guess we got a lot to talk about, Guy, and we'll continue doing that. I'm going to mention the case of the Air Jamaica pilot who was smuggling cocaine into the United States and gets caught. And while he was being prosecuted, he was out on bond, and he took off for the friendly skies and was found years later in a prison in Portugal that was like right out of the 12th century, medieval torture times. And what happened from there was quite a crazy story. So we'll get into that.
We sure will. Until then, you're free to go.
You're free to go.
Down Low Investigations is a sponsor of You're Free to Go. Behind every great criminal defense attorney is a great private investigator. That's why Mark and I use Down Low to investigate cases all over the country. Down Low can help you too, whether you're running a background check on an employee or running a background check on a blind date, or let's say you need someone followed or some other type of investigative work conducted. Down Low is the way to go. Call Download Investigations at 561-843-1806. Everything expressed and discussed in this episode are the opinions and experiences of attorneys Guy Fromston and Mark Nurek and their guests. All ethical rules are complied with. Attorney-client privilege and confidential information is not shared or released during these episodes, and names, dates, locations, and other identifying information may be changed to protect confidentiality. Topics are embellished, and none of the statements made constitute legal advice and should not be considered or relied on as such.